Good afternoon to all the viewers of KCGC TV. Myself, Dr. Renu Saini from Khalsa College of Law, Amritsar, Assistant Professor there. The topic of today's session is extradition with special reference to fraud in banking sector. As we all know, that state exercise complete jurisdiction over all the persons within its territory. But a difficult problem arises when a person, after committing crime, he runs away to some another state. So the problem is how to exercise the jurisdiction over that person which has fled away to some another state. Now it can be sought out with the help of international cooperation among the states. The inability of a state to exercise its jurisdiction would seriously undermine the law and order of the civilized society. So, international cooperation is needed to get back that criminal because it is an important principle of criminal jurisprudence that no crime should go unpunished. So, to punish that criminal, it becomes a social necessity to punish that criminal so that the society would learn a lesson from it that they have not to commit that crime and to escape the punishment. So, there is a legal maxim which says that aut dader aut judiciar, which means a state must surrender the criminal to a state where he has alleged to commit the crime by the state where he is presently residing, and the state should either punish that criminal or prosecute him in its own courts. So there is no universal rule of customary international law which imposes duty of extradition. The concept of extradition got prominence in the 19th century with the advancement of technology and communication. So as there is no convention on extradition, so it depends mostly on bilateral treaties. So extradition treaties and municipal legislations, they are the guiding principles for determining the extraditable crimes. So generally, the extradition crimes like political crimes, like military crimes, or the offenses relating to religious crimes, the persons accused of these crimes, they are not extradited. So the problem remains there when a state is unable to exercise its jurisdiction within the territory of another state. So the awareness among national decision makers of the social necessity of jurisdictional cooperation is well illustrated by returning a criminal or accused person to a state where he has alleged to commit the crime, and this process is called extradition. The term extradition has been very appropriately defined by Professor Oppenheim. Oppenheim has defined the term extradition. Extradition is the delivery of the criminal or an accused person to a state where he has alleged to commit the crime or is convicted of a crime by a state where he happens to be for the timing. So there are certain conditions which are called the essential conditions for extradition. Before accused is extradited, those conditions must be fulfilled. First condition is person accused of political crimes, they are not extradited. Second is persons accused of military crimes, they are also not extradited. Third one is the persons accused of religious crimes, they are not extradited. Next condition is rule of speciality, which means for which specific offense we are demanding or requesting the accused to be extradited, we have to punish him, we have to try him for that specific offense. This is called the rule of speciality. Next condition is rule of double criminality, which means that offense must be an offense in the state to whom we are making the request for the extradition of the accused, and that must be considered an offense in that state also, and it is an offense in the state where he has alleged to commit the crime. Next condition is of prima facie case. It is a very important condition of extradition. So we have to establish the prima facie case against the person who is accused, only then he is extradited. prima facie means it appears from the facts itself that the person or the accused or the convicted person has committed the crime. The important landmark case on this is of V.S. Tarasov case, where it was alleged that the person has committed the crime and he has to be extradited. For this, the court has laid down certain requirements where it said that the degree of witness of the person must be higher than the ordinary situations. Second is, the evidence adduced must be so strong that it should appear from the very face of the evidence that the person has or the accused has committed the crime. Then the degree of proof should be higher than in the criminal prosecutions. So if all the conditions are satisfied, only then the prima facie case can be established against a person. Then all the formalities and conditions involved in the treaties, they must be complied with. This is another condition. Another condition is that there must be a bilateral treaty between the states. Mere agreement or notification is not a valid treaty. Then another condition is where the accused has committed the crime. It is not necessary that he must be present in the state where the crime is committed. This is another condition. And the last condition is states do not allow the extradition of its own citizens. Then coming to the landmark case laws on the point, first is of V.S. Tarasov case, then we have the Savarkar's case, then we have the Dr. Ram Babu Saksena's case, then we have the Sucha Singh's case, then we have Dharam Teja's case, then we have the extradition of famous music director Bollywood Mr. Nadeem's case, then we have the case of the extradition of Abu Salim. Coming to the recent ongoing cases of extradition which relates with the fraud in the banking sector. Before discussing these cases, I would like to discuss the definition given by RBI, Reserve Bank of India, on the term fraud. Fraud, according to RBI, it is an act which is done deliberately with some intention to get some benefit out of it during the banking transaction, or it is whether it is maintained in the books of accounts which are manually maintained, or it is with the help of computer system, and whether the banks, they are with or without loss, or the monetary loss, it can be temporary or otherwise. Keeping in mind all the things which are there in this definition, these three people, they have committed fraud in the banking sector. They are the Vijay Mallya, then we have Nirav Modi, and then the Mehul Choksi's case. As we all know, banking sector is the backbone of economy of a civilized society. When these people have committed fraud in the banking sector, they have affected very badly the banking industry of Indian state. Talking about the Vijay Mallya, he was the tycoon of liquor and he has committed money laundering, and he was liable for money laundering of the amount of 9,000 crores. He has taken this amount from different banks in the shape of loans, and he had fled away to UK on March 3rd, 2016. He was there and India started proceedings against him, and then UK government, after being satisfied, then it gave that prima facie case was not strong enough against him because of the admissibility of the evidence. So more evidence were adduced by the Indian government, and finally on 4th Feb 2019, it was declared by the Home Secretary of the UK, Sajid Javed. He declared that the approval of the Vijay Mallya's extradition is there. So he approved the extradition of Vijay Mallya. For this order, Vijay Mallya applied for appeal against this order, but it was dismissed by Justice Stephen Irving and by Elizabeth Lang, that is two-member bench of the Royal Courts of London, Royal Courts of Justice in London. So afterwards, his extradition was approved by the UK government. But still, he has not been extradited. It is due to some secrecy of the legal matters involved into this matter, which the UK government is not officially announcing, but it seems that he has applied for political asylum in the UK. So his extradition proceedings will not be decided till the final decision regarding his petition for asylum will be there. Lately, in the month of July 27, 2021, it was decided by the Chief Insolvency and Companies Judge, Mr. Michael Briggs. He decided in favor of the Indian banks. Indian banks were represented by a legal team which was represented by Markia Shekardemian, who was the barrister from the side of Indian banks, and she argued that the court should order for the favor of the Indian banks and the Vijay Mallya should be declared as bankrupt. Finally, on 27 July 2021, Justice Michael Briggs, he declared in a virtual hearing in the Chancery Division of Courts, Mr. Mallya as a bankrupt. So the decision is still pending whether the Vijay Mallya should be extradited to the Indian government or not, because his asylum petition is still pending in the court. Next is the case of Nirav Modi. Nirav Modi is also liable for money laundering for $2 million for purchasing apartment in London. He, his wife and his uncle are liable for fraud in the banking sector from different accounts, bank accounts. He fled to UK and finally he was arrested in 2019, and the first schedule of his trial was over in the May 2020, and the appeal was pending over there, and it was ordered by Priti Patel, who was the Home Secretary of the UK, that the Nirav Modi accused must be extradited on April 15, 2021. Against this order of Priti Patel, the appeal has been filed by the Nirav Modi, which was rejected by the UK government, UK courts, and it was lately on 14th July 2021 that different Punjab National Banks, they have through different multiple applications, they have applied for seizing of the assets which are approximately of 2 crores, and his appeal would be heard on 14th December 2021. Next case is of Mehul Choksi. Mehul Choksi is a fugitive Indian businessman, and he is a citizen of Antigua Barbuda. He has been alleged for criminal conspiracy, criminal breach of trust, then delivering of property, corruption and money laundering. He has been liable for, again, fraud in the banking sector. So he was there in Antigua Barbuda, from where he ran away to Dominica, and it was illegal entry. Again, the case was, criminal proceedings were initiated against him under Section 27A of Immigration and Passport Act. So he filed for bail to Dominica High Court, where it was rejected in the month of June 2021. Then in the month of July 2021, he was granted bail on medical grounds, and it was held by the Dominica High Court that Choksi has to pay 10,000 Eastern Caribbean dollars as a security, and he will come back to face his trial in Dominica High Court when his doctor will give him a certificate that he is fit to stand the trial. So now coming to the question of what is the India's policy on extradition. India took a tough stand on fugitive economic offenders in the last few years. So it legislated a Fugitive Economic Offenders Act in 2018, and Enforcement Directorate got Vijay Mallya, Nirav Modi and Mehul Choksi. They have been declared as fugitive offenders by the different courts. So UK government has recommended the approval of Vijay Mallya's extradition, and it also recommended the extradition of Nirav Modi, and the citizenship of Mehul Choksi has been cancelled by Antigua Barbuda. Keeping in mind all these things, Indian government has taken number of concerted efforts on it, and after a long persuasion and vigor, it has been able to get into with treaties with different states, and it signed treaties with almost 51 nations and the extradition arrangements with 11 nations. For the last few years, we have seen that we have gone for 27 extradition cases, which we got back on the basis of extradition treaty with different nations. Now, concludingly, it can be said that if there is a delay in the execution of the extradition proceedings, then the need is to bring out the more streamlined process, and there should be more stronger cooperation between the nations to crack down this evil against the society in a collective manner. Only then we will be able to punish the criminals, and then we will fulfill this requirement that no crime should go unpunished. Thank you very much.